The U.S. District Court of Southern District of New York concluded Friday that Brian Flores, Steve Wilkes, and Ray Horton's ongoing discrimination case against the NFL will proceed in open court. And the fact of the matter is, Brian Flores should be a head coach right now. I'm surprised he did not get the Pittsburgh Steelers job, but the fact that
The NFL just lost control of its own courtroom. After 2 years of legal warfare, a federal judge in the Southern District of New York ruled Friday that Brian Flores' discrimination lawsuit will proceed in open court, not behind closed doors in arbitration. And here's what makes this explosive. The NFL fought tooth and nail to keep this case private, where Commissioner Roger Goodell himself would serve as judge, jury, and executioner. That arrangement just got thrown out completely.
Blackballed, point blank, period. Here it says, 4 years ago, Flores sued the NFL alleging the league was rife with racism as it pertains to its hiring practices for coaches. Wilkes and Horton joined the lawsuit after Flores' initial lawsuit. The court's decision recognizes that an arbitration forum in which the defendant's own chief executive gets to decide the case would strip employees of their rights under the law.
Let's be clear about what arbitration would have meant. Roger Goodell, the man who answers directly to the 32 team owners being accused of systematic discrimination, would have been the sole decision-maker on whether those same owners discriminated. The conflict of interest is so blatant it's almost comical. Flores' attorneys Douglas Wigdor and David Gottlieb called it exactly what it is: a rigged system designed to strip employees of their legal rights while letting the defendant's own CEO decide the verdict.
For the NFL to recognize this and finally provide a fair and neutral and transparent forum for these issues to be addressed. The NFL fought to move the case into a private arbitration, which would have had Commissioner Roger Goodell acting as the judge. So Roger Goodell was going to get to be in charge of this. Nope, you are not in control of this one. In fact, you are under.
Now the stakes get real. This case names the Miami Dolphins, New York Giants, Denver Broncos, and Houston Texans specifically. Steve Wilkes joined the lawsuit targeting the Arizona Cardinals. Ray Horton added claims against the Tennessee Titans. All three coaches are alleging the same core issue: the Rooney Rule, which requires teams to interview 2 external minority candidates for head coaching positions, has become a sham. Teams conduct performative interviews with black candidates they have zero intention of hiring, just to check a box and avoid league penalties.
Complaint obtained by Fox News Digital. Horton alleged he was part of a sham interview process when he interviewed for the Titans job in 2016. This is crazy, man. The NFL, Brian Flores isn't walking away. John Gruden isn't walking away. Here we go over to Pro Football Talk, where it says Brian Flores is tearing down the NFL's house justice system. Here it says
Here's where Flores' case gets personal and specific. In February 2022, he sued the league after being fired by Miami, despite back-to-back winning seasons. But the smoking gun came from text messages he received from Bill Belichick. 3 days before Flores was scheduled to interview with the New York Giants for their head coaching vacancy, Belichick accidentally texted him congratulations. The problem? Belichick thought he was texting Brian Daboll, the white offensive coordinator, who apparently already had the job. Flores hadn't even interviewed yet. His scheduled meeting was literally a sham to satisfy the Rooney Rule.
The problem is simple. The league wants civil cases filed against it to be determined not by an independent party, but by the league itself. So they feel like they're above being ruled or judged by anybody else. They're going to make the final decision on claims that come up against them, but it did not work this time. Here it says, finally, independent judges with the power to do so.
And this is the part that should terrify the NFL. With the case now in open court, discovery becomes a weapon. That means depositions under oath, internal emails, text message chains between owners and executives, hiring committee notes. Every piece of documentation about coaching searches for the past several years could become public record. The league spent millions in legal fees trying to force this into private arbitration specifically to avoid this exposure. They just lost that battle completely. Think about what gets revealed in discovery. We already know from the John Gruden case that NFL emails can be devastating. Gruden lost his job as Raiders head coach in October 2021 after leaked emails showed racist, misogynistic, and homophobic language, Those emails came out during the Washington Commanders' workplace investigation. Gruden is now suing the league, claiming he was selectively targeted when those emails leaked while others involved faced no consequences. That case is also heading to open court instead of arbitration.
Right? If a case is filed against the league, it should be able to be seen by a judge, not the damn commissioner of the league that is being filed against. Like, come on, like let's be real. Let's be real here. Let's be real here. Roger Goodell isn't going to come down hard on the league. Like, he's going to be on the league and the owner's side. So things like this should be seen by an independent, by a judge and all of that and stuff like that. Not Roger Goodell seeing over it. No, it shouldn't work that way because his ass needs to be examined too.
The pattern here matters. The NFL's standard employment contracts include mandatory arbitration clauses specifically designed to keep disputes out of public courtrooms. It's not unique to football. Most major corporations use similar language to avoid jury trials and public discovery. But what makes the NFL's version particularly egregious is who serves as arbitrator. In most corporate arbitration, cases go to neutral third-party services like the American Arbitration Association. Those services have their own bias toward corporate interests since companies fund the system, but at least there's a pretense of neutrality. The NFL doesn't even bother with that pretense. Their contracts specify that the commissioner himself decides employment disputes, the same commissioner who reports to the owners, the same owners being sued. It's the legal equivalent of letting a defendant serve as their own judge. And somehow the league has defended this arrangement for years by essentially arguing that's how we've always done it.
To force employees into arbitration handled by one of the various companies like the American Arbitration Association that exists for that purpose. It's still a much better forum for corporate America than the traditional judge and jury process, especially since the various companies that provide arbitration services tend to skew toward the interests of the businesses that are responsible for creating the system that funnels them so much business. So, this thing isn't going to go away, man. Roger Goodell.
Now, let's address the elephant in the room. Brian Flores should be a head coach right now. After getting fired by Miami following a 9-win season in 2021, he went 24-25 overall in 3 years with a Dolphins team that was rebuilding. He took them from 5 wins to 10 wins to 9 wins. Both his final seasons were winning records. Compare that to some of the coaches who got hired or retained since then. Matt Rule went 11-27 with Carolina before getting fired and immediately landing the Nebraska college job. Nathaniel Hackett lasted 1 season in Denver going 4-11. Frank Reich went 9-8 with Indianapolis in 2021, got fired after a 4-5 start in 2022, then was hired by Carolina and fired again after 1 season. Meanwhile, Flores is a defensive assistant with the Minnesota Vikings, not a coordinator, an assistant. Despite having a better coaching record than multiple current head coaches, the circumstantial evidence of blackballing is overwhelming.
We will see how this happens, man. Put down in the comments if you think Brian Flores is being blackballed by the NFL from head coaching jobs. Get down in the comments, let me know.
Here's what makes this significant beyond just Flores' individual case. The lawsuit alleges systematic, chronic racial discrimination across the entire league's hiring practices. That's a pattern and practice claim, which means if Flores wins, the implications extend far beyond his personal situation. It could force structural changes to how the NFL conducts coaching searches. It could invalidate those mandatory arbitration clauses in future contracts. It could open the door for other coaches, coordinators, and executives who believe they were discriminated against to file their own cases. And the timing creates maximum pressure. The NFL is currently negotiating its next collective bargaining agreement with the players' union. Television contracts are up for renewal. The league just expanded its playoff format and is exploring international games. Commissioner Goodell's approval ratings among fans have never fully recovered from the kneeling controversy and his handling of domestic violence cases. Now add a public trial about racial discrimination in coaching hires, with discovery potentially exposing decades of internal communications. The league's preferred strategy has always been to settle these cases quietly, make them go away with non-disclosure agreements and arbitration decisions that never see daylight. Steve Wilks, one of the co-plaintiffs, actually won his arbitration case against the Cardinals and received a $4 million settlement in August 2023. But that was private arbitration. The details only came out because Wilks chose to disclose them. Most arbitration results stay completely confidential. Open court eliminates that option. Every filing becomes public record. Every witness testimony gets transcribed. Every exhibit entered into evidence can be reported on by media. The NFL loses control of the narrative completely. Watch how quickly the league's legal strategy shifts now. They'll move from "this should be an arbitration" to "this case has no merit and should be dismissed." When that motion fails, they'll pivot to settlement negotiations, trying to make this go away before discovery really begins. But Flores and his co-plaintiffs have already demonstrated they're not interested in quiet settlements. They filed this lawsuit publicly in February 2022, knowing it would make Flores radioactive to NFL teams. They've maintained the case for 2 years through every legal maneuver the league could throw at them. They're not backing down now. The other factor working in Flores' favor is public opinion. The lawsuit gained massive media attention when those Belichick text messages became public. The image of a black coach finding out his interview was a sham before it even happened crystallized the Rooney Rule problem in a way that years of statistics couldn't. As of the 2024 season, there are currently 6 black head coaches out of 32 teams. That's 19% in a league where roughly 70% of players are black. The disparity is obvious and indefensible, but here's where it gets legally complicated. Proving discrimination requires showing that race was a determining factor in hiring decisions. The NFL will argue that coaching hires are subjective decisions based on scheme fit, personality, organizational culture, and dozens of other legitimate factors. They'll point to the black coaches who did get hired as evidence the system works. They'll argue that Flores' firing from Miami had nothing to do with race and everything to do with his contentious relationship with management, particularly regarding quarterback Tua Tagovailoa. That's where discovery becomes crucial. If Flores' legal team can find emails or text messages showing racial bias in hiring discussions, the case becomes exponentially stronger. If they can establish a pattern where black candidates consistently get interviewed after decisions are already made, that supports the sham interview claim. If they can show that white coaches with worse records get hired or retained while black coaches with better records get passed over, that statistical pattern becomes powerful evidence. The Wilkes case provides a template. He was fired by Arizona after going 8-9 in his only season, despite the team starting 1-7 before he took over as interim coach. He alleged the Cardinals treated him as a bridge coach, with no real opportunity to succeed, then conducted a sham interview process before hiring Cliff Kingsbury, who is white. Kingsbury went 28-37-1 over 4 seasons before getting fired. Wilkes won his arbitration case, suggesting an arbitrator found his discrimination claims credible even in the NFL's preferred forum. Now imagine that same evidence presented in open court, with media coverage and public scrutiny. The optics become impossible for the league to manage, and if Flores wins, it sets precedent for future cases. Other coaches who believe they were discriminated against suddenly have a roadmap for successful litigation. The NFL's mandatory arbitration clauses get challenged in other cases. The entire system the league built to insulate itself from accountability starts crumbling. That's why this ruling matters so much. It's not just about Brian Flores getting his day in court. It's about whether the NFL can continue operating as if it's above the legal system, using arbitration clauses to avoid real judicial oversight. Federal judges are increasingly skeptical of these arrangements, particularly in employment discrimination cases where the power imbalance is so extreme. So where does this go from here? The NFL will almost certainly appeal this ruling, trying to get it overturned by the Second Circuit Court of Appeals. That could delay the case another year. But if the appeals court upholds the decision, the league runs out of options. They either go to trial or settle. And given the discovery exposure, settlement becomes more attractive despite the precedent it sets. For Brian Flores personally, this is about more than money, or even getting a head coaching job. It's about vindication. It's about proving that his firing and subsequent blackballing were racially motivated. It's about forcing the NFL to acknowledge that the Rooney Rule has become a performative exercise rather than a genuine tool for increasing minority hiring. Win or lose, he's already accomplished something significant by getting this case into open court where the evidence can be examined publicly. The question now is whether the NFL learned anything from this process. Will they reform their arbitration policies? Will they create genuine accountability in coaching searches? Will they address the obvious disparities in hiring and retention rates? Or will they fight this case to the bitter end, settle quietly if they start losing, and continue business as usual? Based on the league's history, the smart money is on option 3. But Brian Flores just made that option significantly more expensive and embarrassing than the NFL ever wanted it to be. And that might be the real victory here, regardless of how the case ultimately resolves. So what do you think? Is Brian Flores being blackballed by the NFL for filing this lawsuit? Should Roger Goodell be allowed to arbitrate cases against the league he runs? And will this case actually change anything about how NFL teams hire coaches? Drop your take in the comments, hit subscribe if you want more sports business breakdowns like this, and let's see how this plays out in court.